You all did a great job this morning. It was a treat to hear about your businesses, and part of what we want to provide for you here is 2 entrepreneur workshops. The first one is going to be facilitated here by my friends at Hanson Bridget. Hanson Bridget is a law firm here in San Francisco, and they really have a wonderful reputation and work with companies just like yours. So you're in good hands here. They hosted us at our pre-event meeting yesterday. They're a longtime friend of Investor Circle. So I'm going to let them introduce themselves, and then after that we'll have a quick break. But please stick around because IDEO is also going to do a workshop on building relationships with your customers. What else should I say about that?
Applying design to ventures.
There we go. Applying design to ventures. So we're thrilled to have you here. I'm going to turn it over to Hanson Bridget, to Jonathan Storper and Leslie Keel.
Hi, I'm Jonathan Storper. I'm a partner at the law firm Hanson Bridget here based in San Francisco. Just a brief introduction to our firm. We're a law firm of 150 lawyers in 5 offices through Northern California. We are based locally, but we reach internationally, and we specialize in a number of things, but for your purposes, we represent social entrepreneurs and investors in those social enterprises. One of the things, in addition, that we've been heavily involved in is B corporations. Our law firm was a founding B corporation, and I chaired the legal working group that helped draft the benefit corporation law in California, which is the first for-profit corporation of its kind that requires both social and environmental performance in addition to creating shareholder value for for-profit companies. So that's a little bit about our background. I'm a 26-year corporate lawyer, and at some point, maybe 6 or 7 years ago, with a number of other people in our firm, I began to see the light and started doing what I could to help facilitate the development of a different kind of economy, one based on social and environmental justice. And we created our own sustainable business practice group, which focuses on mission-related companies. So that's a little bit about who I am. Leslie, my colleague, is going to start off our presentation about how to structure your deal. You're all looking for money today, so you can become sustainable and keep a long-lived company, and we're going to take you through some of those parts. What we'll do is, because we only have an hour and there's a lot of material to cover, if you would bear with us, we're going to go through each part, and then we're going to stop and let you ask questions if you have them. So, and also this is being filmed today for posterity on YouTube. I'm not sure if that's a good or bad thing, but depends on our performance. But we're going to stop and repeat your question so you'll have a chance for everybody to be heard. So turn it over to my colleague, Leslie Kyle.
Thank you, Jonathan. As Jonathan said, Hanson Bridget has a sustainable practice group at Hanson Bridget, and I started at the firm about 5 years ago, and I was quick to discover the Sustainable Practice Group, and I've been proud to be a part of it and participate in the growing movement here in San Francisco and the Bay Area and beyond. So I'm very excited to be here, and happy that all of you are here so that we can share a little bit of what we know. So the first thing I'm going to talk about is convertible notes. And I just to get a sense of where people are in their stage of development, if I could just take a quick poll, how many of you, with respect to your companies, have done a convertible note already? All right. Okay. Good to know. And then how many of you have gotten to the Series A preferred round stage? Okay. So some of this will be review. So for those of you who already know, please feel free to chime in with war stories or caveats of your own when we have a chance to stop for questions. So convertible notes. For those of you who haven't been through this process already, a convertible debt round is usually kind of the first stage after you raise some money from family and friends. The convertible note is the time where you raise a debt round. You're taking on debt for the company, and it's prior to going out and raising a more formal preferred investment round. So this is often referred to as bridge financing. It bridges the gap between your initial fundraising round and a more formal venture capital round, perhaps with a preferred investor group. So convertible means it's going to convert into that later stage of investment structure. So first it's going to be debt, and then if you raise a preferred round, it's going to convert into those shares of the preferred stock. So because it's typically referred to as bridge financing, the term is going to be relatively short. You're looking at a window of time just long enough to get you enough funding and enough runway to get to your preferred round. So, 1 year, 3 years, 5 years would be probably like the far, far outside term. The conversion is either going to be optional or automatic, or both. So as a company, from a company perspective, you're going to want an option or an automatic conversion only when you actually do that round of financing. And there's a lot of structure around how that round of financing is referred to and how it's structured. So, it's a trigger for when they're going to become preferred investors. And that's, you're going to put some caveats around that. Is it going to be 2 million, 1 million, et cetera? I see that we have a question, but I'm going to hold until then. On the investor side, they want the option to convert. So say it's been, a year and a half and you still haven't done your preferred round and they get antsy, they may want the option to convert into common stock or something else, depending, or to force you to convert or whatever. So you've got kind of this interplay between optional and automatic, or both. The discount rate is usually heavily negotiated as well. So this is kind of a built-in discount off of the number of shares of preferred stock that the debt converts into. So, if you have $100,000 note and you've got a 25% conversion, you're going to get 25% more shares than the other people when you convert.
And I just want to add,
Yeah.
I'm going to just from time to time add a couple things, and that is, why would anybody ask you for a discount? It's because you're at a riskier stage of the company and you're trying to give a sweetener to entice somebody to come in. And so that's everything we're going to be talking about today is negotiable, right? And so there's no standard, you're going to absolutely have to do it. But I wouldn't offer it, but obviously if you're trying to get somebody's money, this is an opportunity to sweeten the deal a little bit. But beware, whatever you offer now, the next person is going to ask you for the same thing. So it's a balance really about how much you're going to offer. I just wanted to add that.
Yeah, that's absolutely. Thank you, Jonathan. And the discount percentage will range depending on what the investor expects. So, discount percentages are one of those things that a lot of people say, oh, well, X% is market. This is what I expect. This is what TechCrunch is giving. This is what so-and-so is giving. And when I'm on the company side, my, response to that is always, market is what we're willing to give you. You can go to some other company and get an X% discount if you want, but if you want to invest in this company, this is the discount we're giving you, right? Okay, well, that's the first part of the negotiation, and it continues from there. But you get the idea. And going with discount is the warrant coverage piece, right? So again, this is a sweetener to your investor to say, hey, if you're going to invest at this risky stage before we've done our preferred round, we're going to give you a discount and we're also going to give you warrants for additional stock. So, and for those of you who don't know, a warrant is basically just like an option. So you get the right to purchase shares in the future at a certain price. And you still have to pay for those shares, but you're locking in your price or the amount of shares or some combination of the both to a future date. So basically, it's a bet that the price now is going to be less than the price later, and they're going to be able to get an additional chunk of shares at a good price.
And that would be better if you had to pick between the two, right? Between discounting the money you're going to get now as opposed to giving somebody the ability to buy more shares and contribute more money later.
Right.
I'd rather take the latter, which is a warrant, right? Which is just an opportunity to buy more shares.
Right. So kind of going back up, prepayment and interest rate. So prepayment is just what it means, just what it says, that you'll, as a company, taking the note, you always want the option to pay in advance. So if you want to pay down that note and not have to convert the full amount into shares of preferred stock, you always want that right. And so, investors will try to narrow that right and say you can only prepay after a certain period of time or between these windows or upon notice or any kind of other number of restrictions. So that's something that you always want to consider. You might not feel like you're in a position to repay it right now, but you always want to leave that door open. And then the interest rate, we're seeing all kinds of structures, I am anyway, because interest rates are so low in the market. So, it used to be a lot more tied to prime rate or tied to something in the marketplace. Now people are just, I want 6%, I want 8%, whatever it is. So you've got a cap at 10% basically, because you can't go past what the state considers to be usury.
That's at least in California.
At least in California. But most people kind of fall between the, 6 and 8% is what we're seeing right now. And then down to security. So in rare cases, investors may be trying to hedge their risk by taking a security interest in your assets. We don't recommend this to a company, and usually it's pretty unusual for an investor to even ask, but we thought we'd put it in just to kind of raise your awareness. So, the main reason why you wouldn't want to give anyone security in your assets at this point is because you're just in a precarious situation. You may want to go out and get a business loan. The traditional lender is going to want a secured loan from you and secure your assets. So if you give the security to your private investor, your kind of hands are tied on a business loan. And you really are kind of hamstringing yourself in terms of being able to kind of buy and sell your assets and do what you need to do in this very early stage of your company. And then finally, covenants. So, again, there's some range of covenants that investors will ask for. Some of them are fairly light, like, they just want financial statements on a regular basis, quarterly or at the end of the year. Some of them are really specific. They want to see EBITDA of a certain amount on a regular basis, or they want the ability to attend a board meetings, or all kinds of things. So they can ask for these things in the note, and they get built in as obligations of the company to the investor, to the person holding the note.
I would just add that to the extent that there are sort of information rights, fine. But you have to be very careful, I think, when the people are asking you for financial covenants, right? Because particularly an early stage company trying to ramp up, but there's a lot of variable that can happen. And so obviously, again, it's negotiable. It probably depends on how much money somebody's going to put in. But I would be very careful about those financial covenants.
Yeah, that's a great point. And also along those lines, you typically don't give any kind of rights, to a smaller investor, right? But once you have a larger investor who gets those rights, it's pretty easy to give those rights to all the rest in the round. So, if someone's going to push for that, then you kind of say, okay, well, how much are you going to put in? So I think we just have one more.
I think you're going to give some examples.
Yeah, just some examples. And then we'll take a little break for questions. So this math just kind of walks you through what happens when you get to the stage that you're converting into preferred stock. So if you've got, missing a zero there, but $1 million loaned, right? And you've got in the note that it's going to convert automatically upon a qualified financing, and your qualified financing is $2 million, right? So that means that you already have $1 million in the bank as a loan, and you went out and raised another $2 million in addition. And again, that's a negotiable term too, right? So you could say that the $2 million includes your $1 million that's going to be converted, or it doesn't include it when you negotiate your note. So another thing to remember. And obviously, it's more favorable to you to have the conversion be pushed out, right? So you don't want the note to be included in the part that's being converted. So anyway, so you take your balance of your loan plus the interest accrued, and then you divide it by the per share price in your qualified financing. So you know, we kept it really simple. We're lawyers, we don't do a ton of math. So if you have $1 per share, and so then you've got 1 million shares for this, for the lender, right? And then if you've got 50 cents, then you've got 2 million shares. Okay, so then we just walked you through this 20% discount concept, right? So if you apply the discount, the lender is going to get more shares, 20% more shares. So they're getting, instead of 1 million shares, they're getting 1.25 million shares. Or if you're looking at a 50-cent share price, they're getting 2.5 million shares instead of 2 million. So, you know, the numbers add up fairly quickly when you do the discount. And so this is just a way to kind of sketch it out for you. And I really encourage all of my company clients to do the math like this when they're negotiating any deal about what things are going to look like in the future. You know, you take your current cap table and you just start, you know, you build a little spreadsheet tab, and you take it and you say, okay, what's going to happen if we earn, you know, if we do a qualified financing of 2 million, you know, how's that going to dilute everyone? What are our lenders going to get? What are the lead investors and the preferred going to get? What does that look like afterwards? And you can just, you know, create it in Excel, so the formulas are all there, and you just punch in the different numbers, you know, different qualified financing amount, and everything, you know, everything changes. And it just gives you a sense of like, okay, this is my future. This is what it's going to look like. Can I agree to this? Yeah?
Yeah.
Okay.
We have to go faster.
We have to go faster. Okay. So any questions on convertible notes? Yeah.
Yeah, I have a few comments, having done this a few times. So I'm interested in your views. So the first question is, why would anybody do a convertible note? Why wouldn't they just sell stock out of the box? So I've had some investors who say, I don't want to know, I don't want to buy stock. What's the price? Okay. So I'd be interested to know what your response to that is. Where did the convertible note thing come from? I have my own ideas about that, but I'd be interested in yours. The second thing is, from my own personal experience, it's very easy to say to somebody, oh, I'll give you a 20% discount. Hey, big deal. Okay, but what happens when the benchmark investor says, you want me to put in $2 million and you got this bozo here who's got a 20% discount? I'm not doing that. So your discount, if it's too high, is a real barrier to the next round. And you better think about that. And you better know in your neighborhood where you live what the boundaries are. It may be different in California than it is in Washington. It may be different in Oklahoma. Be very careful, because you can think you did a great deal and then find out that the benchmark investor is going to take a hike because you gave too big a discount. So I'll be interested in the answer to your first question that I gave you. Why do it at all?
Okay. So the question is, just for the benefit of the video, why do convertible notes at all?
It's a very good reason that I always use, but I'm curious to know what you tell people.
Well, I mean, my first answer is, of course, you know, don't do a convertible round. Don't sell stock. Just wait. You know, I mean, that's my first response, is that if you feel like, you know, you're going out, a lot of people are not even going out and doing this round anymore, and not selling stock, and are just trying to bootstrap until they need they absolutely need the money. So that's the first thing. And then the second thing is, I think, you know, you're giving up control, right? Once you invite people into the inner circle of shareholders, there's another person to contend with. And I've seen that happen, and those people become barriers to doing the next round, and it leads to a lot of problems, because they're not the close-knit group of founders or family of founders that are willing to just sign off on whatever the founders think is the right thing to do. They have their own opinions, and those opinions can really throw off your benchmark investor, or what you're calling. Yeah.
I want to add a corollary comment, which is the reason to do a convertible note now is because if you're the entrepreneur, you may not know what the value of your company is, and you don't want to undervalue your company, and yet you may not get somebody who's willing to take the risk to value it as high as you think it should be valued. So this is a bridge, as we said at the beginning, right? The discount, as I mentioned, I mean, you mentioned that, and as I said at some point, interrupting Leslie at some point, think about it, because if someone wants that, you're going to hear about it in the next round. And one of the comments is, I either want that discount or you've given too much of a discount, and your big lender or your big investor is going to make you go back and renegotiate. So you could see it again. So it is something to think about very carefully, I think. And I think the gentleman makes a very good comment about know your market as well. So, but I think on the other hand, it is a good opportunity to get the money in early when you need it, when you're not ready to value your company and know how much you want to give up. And in the note, you're going to say, we're going to price it based on when the round comes in. And that round is 1 year, that round is 6 months, that round is 3 years. You don't know. But when you have your big round, these people are going to convert in based on whether it's optional or automatic. And then you'll know what the value is, right? Because you've gone out truly to market.
If I could add one thing, so when you're out raising money, you're in a sales mode, and your lawyer is in a defense mode. So the thing is a little different. When I'm out raising money from angels, and I've done a lot of that in my life, one of the key things for me is to appear like I care about the angel. So what I say to them is, we're too early on to know what the company's worth. The last thing you want to do is overpay. Your best insurance against paying too much for this company right now is to have a convertible note, because down the road, some big smart VC is going to decide what the company's worth. We're not. And you'll get protected. You'll always get a better deal. And that has been very, very persuasive to get angels to write checks, because they're always concerned about, well, how do you know what your company's worth? You're pre-revenue. You don't know what your company's worth. I'm going to get screwed. It's a very good sales tool.
A comment?
Oh, a question on that topic. So, if you're already making revenue, like how do you know whether to do the convertible note or put a valuation on the company? I mean, I know, like you said, the benefit of convertible note is if there's not a certain valuation. Like if investors are going back and forth with you, like, oh, I don't want to do a convertible note, I'd rather value it now. I mean, what do you see is the general range of revenue that companies have that do convertible notes, and then when do they consider doing the Series A instead? And it could be different for the different industries.
You know, it's all over the place. I don't know that I can answer that as something standard. You usually see people get in for a few $100,000 in convertible notes, but by the time you're above $500,000, I often tend to see it goes to some kind of round. But that's just, you know, that's just a peg. It doesn't hold true for everything. But usually after through a few $100,000 worth, you're usually moving into some kind of round. And it really depends on your business and how much money you need too, right? Because some businesses don't need very much to do what they need to do, and other companies are very capital intensive, but other people may have other comments. Gentlemen?
When we did that note, the lawyer said something I'd be interested in your comments on. He said one of the reasons to do a convertible note, except for the excellent reason of avoiding the valuation question, is that to do an A round is going to cost you a ridiculously large amount of lawyer's fees. Whereas a convertible note is much, much cheaper. So your sales pitch to the investor is, look, why spend out of a relatively small amount of money? Whether it's coming out of our pocket or theirs, it's still coming out of the deal.
Yep.
Well,
that's absolutely, that was what I was going to say next.
And the other side, of course, is that it helps, I mean, the investor's getting debt rather than equity, right? So they get paid back first until it converts. So from their perspective, they're better protected. If you're the entrepreneur, you'd rather have equity probably eventually, because you don't pay equity back. Anyway, we should go. We need to go faster. Sorry.
Faster.
Sorry about that, but we have a lot to cover.
Yeah. So we haven't even gotten to the interesting part. So term sheet. So now we're moving to preferred round, really, and talking about term sheets. The paperwork, as this gentleman over here said, once you start dipping your toe in the preferred round, the paperwork goes exponentially up. So the first place you start with a preferred round is a term sheet. And it basically lays out all of the basic terms of the rights and obligations of the investor with respect to the stock that they're buying and the stock that you're basically creating for them. So there are several documents involved, and the term sheet is going to drive which ones get created and which ones are not needed. So is it binding? Most of it is not. There's a few things that are in the term sheet that you will be required to adhere to. So the no shop and the confidentiality are usually the binding things. No shop is basically an exclusivity provision. Once you sign this term sheet, you're not going to go out and try to raise money from other lead investors. You know, I'm talking about negotiating with a major lead investor that you're going to go with them. And then obviously you're going to try to get the investor to agree to a confidentiality provision. Lots of times there's pushback on that. You know, really the way around that is to just hold your secrets close to the vest as long as possible, and wait as long as you can before sharing any secret sauce with them. So, you know, to the extent you can, that's great. And once you're really sure that they're committed, is the time to kind of finally disclose everything about your company or how everything works.
Sometimes, by the way, I've actually seen in patent situations where you have a third-party verifier. In other words, a third party who tells the investor this really works, because they don't want to tell the investor how it works. But the way to do this, by the way, is make sure you have your IP, you know, your provisional patent filed, all the rest of it. But if it's a trade secret, that could be another way to verify what you have. It's rare to do it that way, but I have seen it. So.
Yeah. And then fees is another big piece of the term sheet. Most investors will expect the company to foot the bill on the whole negotiation of the preferred round, and we usually recommend that you try to cap that you're only going to pay a certain amount. If their attorney goes over, that's going to be their responsibility. Whether or not you can actually get that cap is going to be a matter of your negotiating power with that investor.
But I would just say that usually venture capitalists expect that, and you just have to give it to them. But if it's an angel, I would push back on it, unless it's a really significant angel, right? Because you're going to have to potentially be negotiating with various angels that you don't want to pay for all their lawyers. So.
Yeah, I mean, I just don't even know if I would go to a term sheet if you're dealing with an angel. You just go directly to documents, try to save on costs. So, just some basics about doing.
Question on that. Where does that fit in with the PPM?
The PPM?
Yeah, I mean, so, you know, do you do PPM and then, you know, generally they're going to get a term sheet or whatever. So, how important is doing the PPM?
Well,
So that's part of the cost feature.
it actually kind of plays into this slide.
Okay.
So, great question. The question was, how does this fit in with the PPM? And
Which is a private placement memorandum, is what that means.
So, really, once you decide you're going to go out and do a preferred round, you have to think about who you're going to go to for that money. And a private placement memorandum, of course, Jonathan, chime in here, but from my perspective, you really need the PPM when you're going out to people outside of your, you know, immediate circle. So if you're going to go out and really solicit people that you know to be have the money to do this, but you don't know them and they don't know you and they're a stranger, then the PPM and that, you know, for those of you not familiar, you know, 50, 60 page document, you know, everything about the company from soup to nuts, plus all the legal disclaimers having to do with risks and things associated with investing in the company. That's a big undertaking, just putting that document together. And so if you're going to go that way, that's like the most official way that you can go out and raise money short of actually going public. So go ahead.
I'm just going to add it also depends on who you're raising the money from. If you're raising the money from very few accredited investors, that is very wealthy people, and there's tests about that you know well, and you've not been around a long time, there's not going to be a lot to say, right? If you've decided for whatever reason, which I don't ever recommend, going to non-accredited investors under certain exemptions, which you can do, then you're going to have to tell them more, and you're going to have much more legal disclosure. It's always better, in my view, when you're a young company without a lot to spend, to find a very few wealthy investors to come in rather than to open it up, because if you open it up and you go into multi-jurisdiction, you have to have much more paperwork. This is about all we can tell you now, because it's very complicated. It depends on what securities exemption you do, but the point is, if you're going out for your first preferred round and you can have a few accredited coming in to do the whole round, that's generally a better thing.
Right.
Probably the paperwork is going to be much less.
Exactly. So, and accredited investors are kind of the safe harbor that the SEC has set up. So there's qualifications around how much income they have and how much net worth they have that makes them, the SEC has deemed them to be a safe investor, or that they're sophisticated enough and have enough money that they're able to protect their own risk, and therefore you don't need to go through the SEC to offer them stock. So just real quickly on the documents that you're going to see when you do a preferred round. The primary one obviously is a stock purchase agreement. That's going to have covenants in it from the company that are much more in depth than the note will have, or than a convertible note would have, and it's going to have representations about all parts of the company, you know, your capitalization, your organization, your authority to do business, all of that kind of thing. And then you're going to see, you know, the other major document is that you're going to be restating your certificate of incorporation and building in all the rights of your preferred stock on that certificate. So those are the two major documents, and I think I'll just leave it there for now because we're trying to get through the slides. But you know, as you negotiate with your preferred investors, the other documents will either come into play or not, but those are the two main ones.
Okay, so dividends, one of the things you're going to have to consider is what kind of dividend rate you're going to offer, and when they're paid and whether they're cumulative or non-cumulative. When paid is up to the board generally, and you can decide that they're going to be given every year, and that they're going to be paid at some particular trigger point. Cumulative or non-cumulative, the non-cumulative means that if they're not paid, then they expire, if you will, at the end of a particular period of time. The cumulative, and they're not paid, they just rack up. So you don't pay, you grant the 3% dividend this year, but you don't pay it. It's added to the next year, and so forth, until there's some kind of liquidation event, and then it's all paid at that time. So these are again negotiable terms. Let's see. Okay. So what is preferred stock? What does it mean? You're all founders, and so you have common stock probably, but you're offering somebody to have a liquidation preference. That means in the event of the company is dissolved, the company gets sold, there's a merger, the company goes public, that these shares get paid first. And what does that really mean? How much is that going to be? And there's different standards for this. So you can have the preferred stock get paid 1 times what they've put in, and then participate in the remainder of the funds that are distributed, and that's called a 1x participating. And I'll give you some examples of this in the next slide. You could say that they're going to get 2x and not participate. That is, they're going to get twice the amount they put in and not participate in the remainder of the pie that's left over for the common when the common is split up. And so those are participating or not. You can cap it 2x, let's say, or 3x. And the trigger events are, as I said earlier, it's going to be a merger, a dissolution, or certain other milestones potentially. So here's some examples. We're going to really go through these really fast because we don't have a lot of time, but this gives you a real hard example of what the differences in terms of liquidation preferences are. Let's say your Series A preferred round raises $1 million. It's based on a $2 million valuation. So that means after the post money is $3 million, right? And they own a third because they put $1 million in. Okay, let's assume there's a sale for $10 million. If they have a liquidation preference that's 1 times what they put in, but it's non-participating, the preferred investors would get $1 million if they don't convert to common, right? They get their 1 times $1 million. But if they decide, I'm not going to do that, I'm just going to convert in, they own a third of the company, you split the $10 million up and they get $3.3 million, right? Let's say you offer them 1x participating though, okay? If the preferred investors would again then get $4 million if they don't convert the common, which is their $1 million, the 1x, and then the remainder is $9 million divided by they own a third, so they get a third of what's left. That's 9 million divided by 3, they get 3, so it's 4. If they decide they're just going to convert, they would convert into 3.3. They're probably not going to do that, right? And a liquidation of preference of 1x participating capped at 3x would be $3 million if they don't convert to common, and $3.3 million if they decide to convert. So this gives you an example of some of the math and some of the things you need to consider when the angels are coming to you and asking for various different kinds of participating opportunities. The conversion usually, when we talked about the conversion, is usually 1-to-1, and the question is whether it's optional or automatic, and we've talked a little bit about that in the other circumstances. It's the same thing here really about when those triggering events happen. Anti-dilution, what is it? It means it's the opportunity to keep your percentage going despite other investors coming in. And for an angel round, I would try to avoid it if you can. It may be something, depending on how big this angel round is, that you have to give, but I'd try to avoid it as much as you can. But let's talk about the different kinds of anti-dilution, because it will be something that you'll face. There's really 3 different kinds of anti-dilution. That is the ability not to have your percentage that you put in sort of diluted out by new investors coming in. It's either the weighted average, which is either narrow or broad, or the ratchet, which is a really bad one from your perspective. So let's talk about the difference between the broad and the narrow weighted average. And it really depends on what the definition of stock outstanding is. If it's a broad weighted average, it includes the common, preferred, options, and warrants, pretty much every kind of security that's out there. You can narrow that though, right? And the more you narrow it, the better it is for the entrepreneur, and we'll show you that in a moment. The narrow only includes the preferred. And the more narrow, the larger the distance to the purchase price, and the greater punitive to the investor. So you want to keep it as broad as you can. So here's some examples. This is the worst one, the ratchet from your perspective. So again, we raised $1 million. We had $1 a share. The pre-money evaluation is now $3 million, and the Series A converts to common on a 1-to-1 basis. So the Series A owns 25%. If you assume in a down round, which is usually when this comes to play, when the price in the next round goes down, you've had a bad year and you're going out for more money. So now you're going to go raise $500,000 a year later in a Series B at 50 cents a share, and the pre-money valuation is $2 million. So it converts to common 1-to-1. So since the Series B owns 20% of the company on an as converted basis, which is $1 million out of 5, if you assume there's no anti-dilution protection, the Series A will own 20% of the company after the sale of the Series B, which is 1 million shares out of 5. But if there's a full ratchet anti-dilution protection, then the conversion price of the Series A gets reduced from $1 to 50 cents. And then thus, the full ratchet means that upon conversion, the Series A will get 2 million shares as opposed to their 1 million set of shares. So that's a lot of dilution. And you can see what that could do to your percentage that you own as an entrepreneur. So that's sort of the worst case scenario, and we tend to not see full ratchets these days. They tend to be one of these other weighted average formulas. It's in your, I'm not going to go through the formula, but it's there for you if you want to use this to work out when you see deals come along. But here it is. I'm going to give you an example of the broad-based weighted average. It's the same kind of consideration, but assume that 500,000 again is raised in the Series B at a down round of 50 cents a share, and the pre-money valuation is $2 million. Upon conversion, okay, the adjusted price is now 90 cents, and the conversion ratio is adjusted to 1.09. So upon conversion, the Series A with the broad-based weighted average protection is entitled to 1.1, et cetera, shares compared to the million that it got, and that's much less punitive from your perspective as an entrepreneur. If it's the narrow-based weighted average, it's not as bad as the ratchet, but it's not as good from your perspective as the broad-based. And it's the same example, so we'll skip down again. You get the Series A gets 1.3 million as opposed to the 1.1 in the other one, or the 1 million if there's no anti-dilution protection. So you can see, and to Leslie's point about getting an Excel spreadsheet and working this out, work with your numbers, because a lot of entrepreneurs don't work with them and kind of get caught short. So really important to see how these work. And you do have the formula in the slides.
Yeah, just to add, I mean, I think that a lot of entrepreneurs, this is not their strong point, you know, and if you don't have a CFO type on your team, this can be, you know, your eyes start to glaze over on this math. But it really, if you don't want to do it, get someone else to do it.
Or get a program.
Yeah, or get
There's software programs that do it, and they're pretty inexpensive. It's really important. This is your money.
Yeah.
This is your company. This is where the rubber meets the road.
Right.
So I know the formulas are really complicated, confusing. confusing, but it's really important. And I've seen so many entrepreneurs not focus on this because they're just focused on getting the money in the door.
Right.
So the protections are important.
Yeah. And it's not so much as it blocking the deal, but just understanding what you're getting yourself into.
Yeah.
So that when you get to this point in your company's, if you're starting to liquidate, you understand how it's all going to go down.
Yeah. Just real briefly, and then I'll take some questions. Redemption used to be the case that all, at least venture capitalists would ask for mandatory redemption after, let's say, 5 years, which was the standard. That's kind of been dropped these days. Some may ask you for it, but here's what you tend to see from investors these days, which is, you know, that's easy for me to give up because the reality is in 5 years, let's say, if I'm in it, I'm in it because the company's making money, and if the company's gone down, I don't actually want to, I'm not going to get redeemed anyway, so what's the point? So if you want to offer this as optional, that's fine. It's not really an important point. I wouldn't fight over it if somebody asks you for it, because they're not going to want to be redeemed in 5 years if you're doing well. Questions on all that? Because I know it was complicated, and we don't have a lot of time, but any questions? Sir in the back?
One question. When people are making an argument for or against weighted, the narrow or broad, are there, in your experience, serious arguments other than brute force? Right? We want you to do it this way because you need us, and so are there good riposts to either of those from outside of the force argument?
Yeah, well, so a couple things. The gentleman here made a comment about know your market and where you are. And we tend to see in the West Coast that these are a little bit more forgiving because the venture capitalists, at least, their idea, at least out here, I think, is let's grow the pie, and out of that pie I'll get enough. And I don't want to squeeze my entrepreneur and make him or her feel like they're a slave. Now, I do tend to find in the East Coast that the terms are a little bit more difficult. That's just what I find. And sometimes even the small points are more heavily negotiated. But I think the argument from the entrepreneur's perspective is, look, I'm in it. I'm going to make you money if I grow this pie. If we're not going to grow it, nobody's getting anything, but don't try to cut me out. Give me a fair deal, certainly not a ratchet. I'd certainly rather have, you know, the weighted average, and we're all going to grow the pie, and I think that it's a matter of aligning yourself with your shareholders in a way where you have mutual trust and respect. And I think that's really the argument. Do you really want to be married, if you will? Because that's what you're doing when you're getting investor, right? You're getting married for a long time. And do you really want to be married to somebody that's going to use brute force? I think you need to be, one thing I see entrepreneurs do that is a big mistake is not take their time because they're trying to get ratcheted up, right? They're trying to scale up fast. This is really an important relationship you're creating here today with everybody in Investor Circle. And I think these people are wonderful. Out in the other part of the world, they may be trying to use more brute force. So take your time and make sure you really interview them and understand who you're getting married to. It's really important. Sir?
What do you think the best way is to get a sense of what sort of the median first quartile, third quartile on the terms, like what a median term would be in terms of the market?
Ask your lawyer. Get connected with a lawyer and ask try to get introduced to other angels and other venture capitalists who you can talk to. There are some reports that are put out, but I think a good lawyer ought to be able to tell you what kind of deals are you seeing, what kind of terms are you seeing. That's really important. Sir?
How often do you see participating preferred versus just preferred?
It's typically I often do see participating, but if I do see participating, then it's usually going to be 1x. Right? You're gonna have to balance these things. If it's going to be 2x, then I don't want participating. I'm going to argue against that. Right? If it's 1x, then I can absolutely. You're probably going to do participating. They're probably going to have that option. So I want to talk briefly about the board, total number. Sometimes when you do the preferred round are going to be elected by the commons, some are elected by the preferred. You might have an outside director. By the time your company is getting geared up, you want some preferred directors if they're going to ask for a role, not just to give you money, but hopefully these are people that also have connections that can help you build your company and give you good advice and good connections as well. We often leisurely advise that 5 is a nice number. Sometimes the big mistake I see is that people decide they're going to have an enormous board, and for some reason social entrepreneurs in particular seem to like large boards of directors because they have a democratic idea and they want to bring in the community. It's a bad idea. It's too many people. You want people who are going to show up at your meetings, every meeting. If you want to have a separate advisory board that gives you advice but doesn't vote, that's fine, but I would try to limit your board to something like 5 or 7 or 4, 3, not 4 actually, something an odd number. And you'll often see angels elect as a group. I wouldn't give one particular angel a board seat unless he or she was a very big angel. But oftentimes you'll see that the angels get together and you want to give them as a group in your round a board seat, and that's not uncommon.
Board compensation.
You know, it's unusual, I think, at the stage you're at. Sometimes if you have some particular board member that's invited on, let's say a PhD in a particular area that can really help you scale, you might give it, but I think the angels are actually going to be glad if they can just get their expenses reimbursed to come to a meeting. I don't think you really have to offer that. Really, you're not, until you get much larger or you go public, you don't usually see compensation. And they're getting, by the way, they're getting paid. The angels are getting paid usually out of their fund, or the VCs are getting paid from their fund, so they're being paid to do that.
What about equity compensation for outside directors?
You probably are going to offer some non-qualified stock options to an outside director. I think that's really typical. Yeah. So get a good equity incentive plan, work with your lawyer on that, and have a very flexible plan that can offer that. Some protective provisions. Some of the protective provisions that preferred investors want to see is that if you're going to have a senior security, that they have a right to vote as a class about that. Liquidation, a change in the liquidation preference or a change in control, amendment to the articles of bylaws. If they're major amendments, usually preferred investors want that right to vote, at least as a class. Obviously, the change in the rights of the preferred investors, they're going to want a right to that. Information rights, Leslie talked about. Information, you negotiate this about what kind of financials you give, milestones and so forth, and usually those are something the preferred will want as well. And obviously a change in the corporate purpose, which is the main part of the company, are often things you see as protective provisions that you give in an investor rights agreement for preferred round. How long are they in effect? Well, they're going to probably be in effect at least until the next round, because the next round is going to renegotiate, and oftentimes until some particular milestone is hit or until you go public. So you do often see that. What are registration rights? Registration rights are the rights when you go public, typically. And again, for the angels, if they're small, I would really try to resist it. And the reason is because it's expensive. But venture capitalists almost always are going to demand that. And a demand right would be when a significant investor at some particular point has a right to ask the company to go and take their shares and register them in a public offering. And the piggyback right is when the company is going to go sell some of its own shares in a public offering, and the investor holding those shares gets a right to piggyback on and get some of their shares or all of their shares registered as well. Now, why is that important? The investor wants a right to get out somehow by having a public market, and that's understandable. However, it's expensive to do registration, so unless this is a very big investor, I would try to resist it as much as you can. And certainly if you have to give in on it, then you want to limit the number of times that they have that right, because every time you do that, there's accounting and there's legal fees, and it can be very, very expensive. So you want to narrow that and work with your lawyer on what are typical provisions in your area. The only thing I'd say about an S3, there's not a lot to say about it. It's just sort of an expedited way of companies of a certain size to cut down on those legal fees. And if you ever get to that size, then you'll work with your lawyer on that.
I do want to say, though, I'm not seeing a ton of investor rights agreements. I mean, I'm seeing very light, very short ones, or not at all in some of the recent rounds that I've done. So I think right now going public is not as important to a lot of investors. They're not really seeing that as even a viable exit strategy, even to put it on the table. So, just kind of keep your eye out for that, because, if you're like, 150% sure that you never want to go public, then there's no reason to negotiate an investor rights agreement.
And Many of the companies in this room, maybe you want to just operate your business and scale up and give a return. And it is true, going public is something that's just not happening as much these days, although mergers and acquisitions are sort of the way for exits. And so, those are something to consider, because it's all negotiable again. Some of the things also you might see in an investor rights agreement that a preferred round, either an angel or a VC might ask for, is a right of first offer. The right of first offer is the right to make the first offer if you as an entrepreneur want to sell your shares, right? They get the right, you have to offer to them first. Second thing you might see is a right of first refusal, that is, to right to make the last offer. This one's a little bit trickier, and I try to have my entrepreneurs resist this if possible, because what it means is you go out and you sell your shares, you negotiate it with whoever you can negotiate it with, you get a bunch of offers, then you have to tell the people that are offering this, oh, I have to go to my investor and I have to offer to them first, and they have a right to review the offer and take that offer. Well, that kind of discourages third parties, obviously, from making an offer to you. So unless, again, somebody is going to be of a significant investor, I try to resist that if I represent a company. Co-sell right is the right to participate in the sale. So if they've turned down the right of first offer, right of first refusal, and the entrepreneur sells their shares, then the investor sometimes will say, okay, I want a piece of that sale. I want to sell pro rata my amount, the amount of that you're selling, some pro rata amount. And that's one thing sometimes you do see, again, if they're a significant investor. Now, there's some exceptions you usually do see, and that's I try to limit those rights to a certain number of shares per year that the investor has a right to participate in. Or obviously, if an entrepreneur wants to shift shares over to a family member or for trust or estate planning purposes. Last slide, angel killers. Here are some things that are really going to be problematic from the perspective of a venture capitalist or an angel if they see in your company. And I always tell my companies from the very beginning, start keeping your documentation from the day you incorporate. Make sure you're working with a lawyer who knows what they're doing, who helps you organize your documents, who keeps a minute book. Document the things that you're doing, the decisions you're making. Keep good records. I know you're moving fast, you're trying to scale up, but these things are going to be important, because when the investor comes in, they want to see that everything is in order, and you want to make a very pretty picture for them as to what you've done. So here's some things that I see that are problematic, at least when you're doing a preferred round. Not having a term sheet sometimes can be a problem. Having a term sheet and then all of a sudden start changing the terms of the term sheet because you're negotiating. Usually if a venture capitalist is offering you money, they're going to give you the term sheet. But with an angel, the company will give the angel the term sheet, typically. Sort of due diligence surprises, or not telling people what's going on. I just was in the Power of Angel Investing yesterday, where we were teaching angel investors, and I heard a bit of a horror story of a fund that had gone, a very sophisticated fund, that had gone down the road, and sort of at the last minute when they were ready to invest, all of a sudden the founder said that the co-founder had dropped out and had been out of the company, and that's something that had not been disclosed. Well, that made everybody pull right back, of course. So be upfront with your investors about what you're doing. This is your opportunity to present yourself, but the people they're having faith in, beyond just the product or service you're putting in, is you. That's who they're investing in, is you. So it's really important to be upfront and to be diligent. Cap table problems, Leslie mentioned those, and this again is really, really important to make sure that your cap table really works and that you've worked out the scenarios. And again, there are programs out there now that you can use. Management structure teams, sort of mentioned one problem that I just heard about yesterday. Not having your material contracts or agreements in writing, not knowing who your customers are, not being able to show the revenue because you're really not able to prove and document. And I've actually seen that more than once. Companies not having documented and coming along and then having to go back to the customer and try to ask the customer to get a writing, which often leads the customer to say, I'm ready to renegotiate our deal. That's a problem. Board composition, understand what you might expect them to ask for, and we kind of went over that already. Not understanding what your exit strategy is going to be, and you can make a decision about what you want to do with your company. Is it to do a merger or an acquisition? Is it to grow your company and have certain milestones and simply give a certain amount of revenue over time? That's perfectly acceptable as well. There's all sorts of different things. You're the entrepreneur and you need to make a decision about what you want this baby you've created to look like. But you ought to have a clear idea about what that is, and you ought to be able to communicate it. There's no wrong or right answer, but except that the wrong answer would be, I don't know. I'm going to do whatever's best. You ought to have a clear strategy about what you think. And it's subject, obviously, to change depending on market conditions, and you can take that to account. Everybody realizes that the market changes. Too many cooks. You ought to have a clear line of authority in your company about what you're doing and who's responsible for what, and they ought to have the kind of background in order to do that kind of job. So it's important to be able to explain the management and explain each of the people you have put into place. And if you don't have the right people, how you're going to go, and you're going to be able to explain how you're going to be able to go use this money potentially to go attract the right people, right? And lastly, the lack of IP. I can't tell you how many times I've heard the story of a startup who says to me, oh, you know, my buddy, he did this coding for me, and he's a great guy because we were college roommates. And you know, I don't have anything in writing, but you know, he's okay, and he's not taking anything for it. Or I promised him that I would give him, you know, 0.5% or something, and he's going to be fine with that. But it's not in writing. First of all, copyright can't be transferred except in a writing. You have to have it in writing. A verbal agreement doesn't work. So if it's software, for instance, just as an example, it doesn't work to do the transfer. You need to have an inventions assignment agreement that transfers these things in writing. That's the first thing. And as I said earlier about the due diligence, that needs to be something that you have because the angel or the VC is going to ask for it. The other thing is you'd be very surprised that the buddy that you have right now, once the company gets going great guns, is going to start asking for more. So the time to do it is early on and to document it early on. So I just caution about that. That's the end of our presentation. Oh, wow. See, you're clapping. But any questions, any additional questions? I know we went really, really fast, and sorry for having to do that, but, sir?
Yeah, I'd just like to add a few things to your angel covers. There was one that I thought for sure you'd have there. And that is one of the things that most people don't do is they don't keep their corporate records in good order.
I did say that.
I didn't hear that. I missed that. And the other thing is your books, your financial records. If your QuickBooks isn't done right, it can do you. And then the last one is if you have confidentiality agreements with your people who work there, having someone who forgot to sign one is a deal killer.
Yeah, I probably really wrap that kind of all up in sort of this documenting these, but you make a very good point. Inventions assignment agreements, confidentiality agreements, in writing, everything's in writing so you can show, and it ought to be in order. What I actually tell my companies to do to get ready for due diligence is get a box, you know, or have it all online. That's fine too if you want to have a virtual room and have it all online. People do that now. In the old days, we'd actually get a file box and label them with your articles of incorporation, all your contracts, all your inventions assignment agreements, your employee agreements, you know, your books and records and things like that. You're not that big at this stage, so it shouldn't be that hard. But that's impressive to walk into a room and give the angel this box, and it's all labeled and it's all indexed. It's not that hard to do, so impressive. Anyone else before we?
One more question,
okay.
And then I think we'll have a little bit of a quick break to switch out, and Jonathan and Leslie are definitely going to be available.
And you can come up and chat with us in between.
But let's have one more question.
Go ahead, and then you.
Maybe two.
Okay.
Yeah, I'd ask about exit scenarios that don't involve the sale of the companies. I run a service business that will generate strong cash flow. Short of selling the business, other sort of cash flow based ways to make liquidity.
Was the question how do you get liquidity if you're a service business?
No, is there sort of an exit scenario that you can propose, a flavor of exit scenario you can propose, sort of selling the company, you know, if you've got strong cash flow but don't have the sale prospect?
Well, it depends on where you are in your career. People who have been doing it for a long time sometimes decide that they're going to sell it to their employees, and they're going to take a note. They might take a note that's payable over time, and they go and retire, and then out of the cash flow comes payments over time, or someone. I mean, sometimes you see that someone within the business buys it. It's too complicated to talk about here, really, but you know, I've seen a rise kind of in the idea of employee-owned stock programs that actually you create a separate entity that buys the stock, and all the employees buy it. Or you go and get a new partner that comes in, right? a new partner that comes in, and you slowly over time sell pieces of the business over time to your partner.
Sounds like a longer conversation.
It's a pretty, yeah. Sir, and then I guess we have to break, but come up and ask if you have other questions.
So you didn't mention with convertible debt kind of a ceiling or a cap on the conversion valuation. How frequently do you see that? Is that something you should shy away from?
A cap on the valuation?
Yeah.
Well, typically what I see is that the note, the value of the note, how it converts in is going to be based on the next round, because you don't really know what it is at this round. You don't really have any idea. I don't.
I think what we're saying is that if valuation runs on the note holder, they're going to get a very small portion of the company. And so he's talking about a collar on the valuation of the note.
Oh.
I'm seeing that more and more. I don't know. I mean, I've actually talked to Hub Ventures about it a little bit. So I mean, yeah, we see them. It's tough. Like I don't like it from the company's perspective. So yeah, but it's a new term that's got invested by one of those incubators or accelerators down somewhere. So I mean, yeah. So it's starting to become quote unquote market to see that in the notes. That's again the conversation where the investor's like, well, this is market. This is what I expect, and it's like, well, we're not offering that to you right now. So, or you do. And you live with it, but yeah, I mean,
that's a tough one.
It's a tough one
because then you've got your next round to deal with. So again, I would try to resist it if I were the entrepreneur.
Thank you.